Angela is in Cheshunt. Angela, good evening. What's your question?
Good evening, Daniel. The question is, I'm in the process of trying to sell my late father's property. We did have a buyer and appointed a solicitor to deal with that for us. We signed for the solicitor their terms and conditions, which stated that if the transaction fell through before exchange of contracts, that their fee would be only 2/5 of their usual fee. It did fall through before exchange of contracts, and they are trying to charge us 100% of their normal fee. I have queried it with them, but they have come back to me with a very curt response saying it was due to the substantial amount of work involved. And I just wondered if I've got anywhere to go with that, to pursue it any further, if there's any point in trying to pursue it further.
Well, I think so, Angela. Let's ask a few more questions if I could. First of all, was the agreement that they'd only charge 2/5 in the event that the contracts weren't exchanged in writing?
Yes.
And were they paid on a percentage of the transaction value or a flat fee?
A flat fee.
So tell me what the fee was.
995.
So they were only going to get £400 plus VAT if the transaction didn't go through?
Yeah.
Would they say that the reason for the transaction not going through was because of you, or was it something else?
Just a little bit more background. We had a buyer that wanted to complete very quickly, so it was a case of, everything was being done at a rapid rate. We were also looking to enter into a licence to occupy, which obviously incurred further work for the solicitor, but they were charging a separate fee for the licence to occupy. And it was only as a result of the solicitor giving us advice, actually, not to proceed, that we didn't exchange contracts.
OK. What was the basis for the advice not to proceed?
The licence to occupy, the details in the licence to occupy, the solicitor wasn't happy with it.
Right. So it can't really be said to be your fault in any way. It was on the solicitor's advice and you hadn't done anything wrong.
I would say so, yeah.
OK. In which case, I can't think of any reason whatsoever why they should charge you a penny more than 400 plus VAT, the 2/5 rate. Their curt reply, well, we did a lot of work, can be met by an equally curt response from you, bite me. I would definitely not pay that money, and presumably they have sent you an invoice. They haven't had money in advance. Or did they charge you in advance?
They only charge £200. It's joint with my sister. She's paid 100. I've paid 100.
So you accept you owe them another £200? Well,
actually, except that I actually owe more than that, because the fee for the licence to occupy is
OK, let's leave that to one side. But for the
yeah.
conveyance, for the
yes.
purchase, you owe them another £200. You accept that. So I would send them a cheque for another £200 plus VAT. Tell them that you're not paying a penny more and that they'll have to issue proceedings against you in the small claims court if they want to try and recover it, because the deal was they get paid £400 if the contracts weren't exchanged. The contracts haven't exchanged. They're not entitled to a penny more. It sounds to me, Angela, like you have a really cheeky solicitor, perhaps one who has to meet a particular target because his or her own job is under threat for one reason or another, and they're trying to eke every penny they can out of you without any moral or legal basis for doing so. And if you can't get any joy, and if you're worried you're going to be sued, your next call of action is to report that solicitor to the firm's senior partner and lodge a formal complaint. And if that doesn't get you anywhere, refer them to the Solicitors Regulation Authority. But the only way they can get money out of you is by suing you. And if you have a copy of a written contract saying they're only going to charge you £400, all you need to do is show that to a judge, and the judge will laugh them out of court, along with probably giving them a pretty stern reprimand.